David presiding. You may be seated.
Okay, I guess I'm supposed to say we're live with voice and video. Not that this is was necessarily on our topics for this morning, but a laptop, a clean laptop for the jurors so they could take back and listen to a disc.
We have that, Judge. Well, not just listen to the disc.
See the photos on it.
We have that, and what we'll do is we'll bring that to the lunch break for inspection by
Okay.
you and by Mr. Strolla.
Okay. Okay. Jury instructions.
Yes, sir. May we remain seated so I can
Yes,
continue to
yes.
edit? Your Honor, I've submitted the final version, which includes Mr. Strolla's copy of Justified Use of Deadly Force. I made some changes that Maria was kind enough to point out on the verdict forms. I have sent both of the finally revised code-form copies to the court and to Mr. Strolla. I believe there's a little more to look at on Justified Use of Deadly Force. I'm giving the court our answer on transfer intent and the or another person. We decided to delete that and clean up the, yes, sir.
Very good.
Well, we just thought it would make them read more efficiently.
I think it does.
And we're not going to request the transfer intent instruction because of the multiple counts.
Okay.
And Mr. Strolla and I agreed to delete the little tiny titles on page 31 that I emailed you about. They're in there, and it doesn't say give it applicable, but remember you told me to remove the one with the defendant because it's in testifies, but those other titles just say law enforcement witnesses, expert witnesses, and it sort of looks off kilter.
Oh,
It gives more attention to those paragraphs than it does to the defendant testifying. So Mr. Strolla agreed to delete those little three subtitles, and I did.
okay.
Judge,
That-
we may.
That's correct, Mr. Stroll.
Yeah, and on the next page, we may have to, I'm not sure if the subtitle of witness talk to lawyers there. It should just read as entirely proper for a lawyer to talk to.
That's another one. I'll
Okay.
put that right.
So we're basically taking out witness talk to lawyer, expert witnesses, and law enforcement witnesses. The little title, but I'll read the
Yes.
paragraph.
And I-
Okay,
And I assume the give only if defendant testified was also stricken.
correct.
Right underneath, if the defendant testified, the title was right underneath it.
It's not, it should be on the new version.
It's not pulling out. I just tried to,
No, we printed you out a copy.
oh, there you go, man. Judge, if I can approach your clerk.
Did I get a new printed copy too?
Yes, yeah, of course.
Oh, up here. Aha,
Thank you.
okay. All right.
And I just corrected that little last paragraph, if the tab is off, I corrected that.
Okay, well, we were good to go. And you changed attempted voluntary manslaughter to attempted manslaughter by act.
I did, and to double check, I read through it all, but also did find the word voluntary for that. The only place it is where it's supposed to be in voluntary renunciation for the attempt statute, so that should be gone. Took out all the or another person. And once we go through justified use of deadly force,
I don't mind page numbers.
Okay, but just take out jury instructions.
Yeah, I wouldn't put done jury instructions at the bottom. I wouldn't put the time and the date. I would just put page
Yes, sir.
1 of however many.
Yes, sir.
I'm just thumbing through them, looking at notes that I had made for myself. Yeah, you know what, I'm looking at page 11. I guess you were right, Miss Corey. That kind of looks, it's lined up, but it does look kind of funny that way, doesn't it? The negligence, justifiable homicide, excusable homicide, the heading, if you want to call it that.
It does. You want it back to be in center?
Yeah, I think it's probably best. Just looks kind of silly.
Well, it's centered on the draft. You want them centered to the far left.
No, what's justified is the N, the J, and the E are all lined up.
Right.
But then it makes it look funny going over to the right. I'd center the word negligence, and then I would center the word justifiable homicide, which is gonna then extend either side. I mean, this is,
I agree. I thought that was the issue you were having where you couldn't do it. Where
Yeah.
It wasn't centering.
No, I had them that way.
I think she did, it
Oh,
just
the last
didn't.
draft said it was on the far left. My last draft was on the far
That
left.
was because I thought you wanted them on the far left.
Right.
I'll put them wherever you tell me.
Yeah, just center them, it'd be
Yes.
fine. Let's see, and hold on.
Judge, do you have any concern at all about how stretched out the instructions where we were reading all three young men's name under count 2, count 3, and count 4? Do you want me to pull those in a little more so it doesn't look quite as awful?
That's fine. You mean take the spacing out between count 2, count 3, count 4, and then their
Well,
names?
The spacing between Michael Dunn, for example, and the attempted first degree murder.
Yeah, you could tighten that up a little bit, I
Yes,
think,
sir.
probably.
Well, then it would make it look like all one paragraph.
Yes.
Can I ask him to look at this, Judge, because
Sure.
Well, I'll make come over there.
if you don't mind.
Yes, 1 second.
We need just 1 second, Judge.
Yes, ma'am.
Okay. Judge, we agree that the tightened up paragraphs would make it easier if you're sending copies back to the jury. So I can go through and do that, before we finalize these.
Okay.
Yeah, except then that would pull that out.
Okay. All right, I've thumbed through all of them. They all look fine to me, with the exception of let's go back over justifiable use of deadly force. So are they okay with you, Mr. Strolla?
Judge, I'm still flipping through if I can just have a moment, Your Honor.
Sure.
I'm just a couple pages behind you now.
That's all right.
Judge, and there were no issues, just to be on the safe side, the attempted manslaughter by act. I just want to make sure that tracks the language of the, because we didn't get to review that last night.
I'm sorry, I missed that. What you said?
Originally, we had the attempted voluntary manslaughter, and then last night made the decision to keep it attempted manslaughter by act. I just want to make sure that it tracked the actual new language. So that was on page 23. A little bit off now. Judge, I'm just making sure I didn't have any other markings from last night. Now you got page 26, justifiable use, Your Honor.
Yeah, so everything else is okay?
Up to 26, I'm with you now, Judge.
All right, Mr. Dunn, again, good morning. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Are you satisfied with the jury instructions, other than we have to talk about justifiable use of deadly force?
I am, Your Honor.
Okay. Okay, so then let's talk about that. One thing that I want to mention is it's been brought to my attention
Just have to change a battery to add. Judge, I do know we have to add permanent injury for the aggravated battery. We were starting to make that change this morning, if I'm not mistaken.
Permit disability.
Disability,
Right.
I apologize.
It's been brought to my attention on page 28, top of the page. This is going to sound absolutely ridiculous. Very first paragraph, if Michael Dunn was not engaged in an unlawful activity and was attacked. As you read further, where it says meet force with force,
Yes.
Yes, Your Honor.
including deadly force,
Yes, Your Honor.
that comma needs to come out.
Okay,
Meet force with force, comma, including deadly force, take the second comma out.
Yes.
okay.
Yes, sir.
Apparently that's, with the comma out, it's identical to the language in 776.013 sub 3.
Yes.
And I'm told, believe it or not, that there's a case that says if that comma is in there, it's reversible error.
And we don't want that touched.
The comment from the state of the jury instruction, Would it be?
Yes,
that
ma'am.
comment? Yes, it's out.
And we have no objection to removing that, Judge.
Okay, good. So then we go
Comma
back.
after including, so it reads the sentence, including deadly force if you
And
use
Judge,
it. So-
we just want to make sure we're clear, if you would read it to us exactly. because
Yes.
We may be using this in, for our purposes.
Right, so it's the first paragraph on the top of page 28. If Michael Dunn was not engaged in an unlawful activity and was attacked in any place where he had a right to be, he had no duty to retreat and had the right to stand his ground and meet force with force, there's a comma there, including deadly force, take the comma out. So it'd be including deadly force if he reasonably believed that it was necessary to do so to prevent death or great bodily harm to himself or another, or to prevent the commission of a forcible felony.
It's out, thank you.
All right, so going back to the beginning, really the only issue we have is the issue of, in my mind, is to the beginning part, which kind of relates to 78202, and then the second part, which really relates, I guess, to 776, and whether to give both. And obviously the state's argued against it. I tend to agree. I think giving both is very confusing. But the defense has wanted both. The only other thing that I noticed that, I'll throw it out there, makes me nervous to say it, is right after, at the very beginning, on page 26, right after the definition of deadly force, and then it goes on and says, the use of deadly force is justifiable only if Michael Dunn reasonably believes. I get worried about the word only.
I think we should take it out, Judge. It's just not worth it. It's one of the ones that
Okay.
I see that they struck on that new.
Okay.
I'll talk about this thing, but, my other concern is, I don't know how you attempt murder, Judge, and the way this reads, if you just took assault and ag battery out, then what Mr. Stroll is requesting is that this jury be informed that Jordan Davis, which of course we don't believe any of this, is what the facts show, but for purposes of the jury instruction, that if you read it, Jordan Davis attempted to commit attempted murder upon Michael Dunn. And I just don't know how you can attempt to commit an attempted crime. And that's why I believe at least one of the cases suggests that if you are going to allow 78202, which we agree now that we should, that it should be an ag assault or an ag battery, because you've already told the jury another's attempt to murder him or another. But I'm just pointing that out. I believe it would cause confusion to the jury to attempt an attempted crime, but
I tend to agree, but Mr. Stroller?
Judge, and I think we talked, there was a case that I believe I gave to the court on an email, and I was looking through some of the research, and we did talk about this last night, and I said it was confusing, but the case law stated it was an attempt of attempted murder, meaning that's an actual charge where if the jury believes that Jordan Davis was attempting to murder him, they could find that was justified shooting. And I know it says attempt for attempted murder, but the case, the way they had it, actually had it listed that exact way with attempted murder in there. So, and again, to go to Ms. Corey saying that it's going to confuse the jury, I think this will probably be about the 10th issue that would confuse the jury with the instructions the way we have it. So it's not an intentional confusion for them. It's.
I think it's intentional. Don't
And I-
misunderstand. I just think if you were to take the other two out and read it with just attempted murder, which the jurors could very well do in their deliberations, I believe it's confusing. If you believe the case law says it has to be in there, we defer to the court. I just don't point that out, Your Honor.
I don't remember seeing that in the case, but do you remember what case it was?
I was reading through on the bullet points, and I remember seeing it actually had in that paragraph attempted murder, and that's why I put it in there. It was one of the cases, again,
Well,
and that was my concern.
maybe we
when I
can
actually
try and
saw
look
it.
and see about that. I guess you could look at it a couple of ways. You could look at it the legal way, where we believe attempt means something different than the normal everyday attempt. You know, when we just talk as normal folks, we talk about attempting to do something. It doesn't carry the significance of an attempt in the courtroom. So I guess you could, if you're a juror, read that and say, any attempt to commit an aggravated assault. It's not an attempted aggravated assault, it's I tried to commit an aggravated assault. I tried to commit an aggravated battery. I tried to commit an attempted murder. Now that sounds kind of stupid, but I just decided I didn't really want to kill anybody. I just wanted to try and kill them. And so that's what I did. I intentionally did not hit them when I shot at them. But it's silly, I get it. So I guess, it depends on, who knows what they're going to think when they go back and look at these things. That's why you're right. I wish, we almost need like lay people on the jury instruction committee to help us, and I'm not on the jury instruction committee, but to help us as lawyers or folks that are in the system step back, get some perspective, and realize, this is pretty complicated stuff.
Yes, sir.
And there ought to be a simpler way to say it that covers the law, but is understandable by folks who are never come into contact with our system other than when they get that notice in the mail to come on down and do their public duty or their civic duty and be a juror.
And Judge, I have to say, it puts the state in almost every one of these cases in the proverbial between a rock and a hard place, because if we fight the jury instructions to conform with what we believe they should be, we risk reversal. And if we allow confusing jury instructions to go back to the jury, we risk a not guilty verdict. And it has happened before, it will happen again, and we are imploring whoever needs to take care of this to straighten up these jury instructions, Judge.
Well, I guess you're imploring the record that's being taken down. Certainly, there's nothing I can do about it. And just for the record, and for those that are watching, I guess, the most disconcerting thing is, while the state and the defense and myself go over these things and go over these things and go over these things, and we agree on what an instruction should be, there is absolutely no guarantee whatsoever that that could not ultimately be reversed by an appellate court when they review the instruction and decide after the fact, that instruction really wasn't very good. We're going to change that instruction, and oh, by the way, we're going to reverse a conviction because that instruction shouldn't have been read, even though that was the proper instruction to read at the time. And so it's and that has happened here locally and somewhat recently, where instructions were read as they were to be given pursuant to the standard jury instructions, and for whatever reason, it was decided that that wasn't proper, even though it was the instruction to read. So
I did read several cases as I was doing our research on that as well, Judge.
You'd love to think that there's some finality to these things, but
And I will only put on record that everyone in this room that is an interested party has spent hours on the new instruction on the voluntary manslaughter by act. And even with the minds that we have in this room, we were still unsure
True.
and unwavering, Judge. So I just want to put that on the record as we go through it, Judge.
yeah, we've had, I don't know how many lawyers from the state attorney's office looking at it, yourself, folks that are helping you, myself, law clerks on my behalf. So,
I just wanted that on the record. Thank you, Judge, and it's still in there, and
okay.
just tell me what else we need to change.
I think if we take out the word only, we've argued about the rest of it. I guess we could look one more time for this case that talks about the attempted murder, and I don't mind doing that, or, well, I won't be doing that. I'll get one of the law clerks to look at it for me. This is a great thing about being an acting circuit court judge. You got all kinds of people that help you do stuff. When you're in county court, you do it all by yourself. So this has been great.
And Judge, we have seen the proposed changes to justifiable use of deadly force that is being submitted as of February 15th, 2014. and they've made a ton of proposed changes. Obviously, it hasn't gone to the committee yet, but I did want my client to be aware that it's out there as of, you know, midnight when we were here, or I was here, that, again, for the record, we've gone over this so many times, we can only go on the standard instruction that's there and use what the Supreme Court of Florida has given us. So, because I agree in that same paragraph, it talks, he reasonably believes, and it should be in past tense as believed, but then once you start making minor changes, you get into that hybrid position, and then now, you know, you make some changes here, not changes there.
Right.
So the reason I left it as believes with an S on the end is because as of today, as of this trial started, and as of these instructions, that is still the standard language, Judge. So I
Probably ought to have an English major on the Standard Jury Instruction Committee as well.
That might make it worse.
Reasonable doubt is one of the longest run-on sentences that I know of anywhere in history, but it probably would, but I think take out words only goes a long way towards the new
Okay.
suggested instructions, and I've taken it out.
All right, anything else other than that on that instruction, other than maybe the attempted murder, which we'll figure out?
Yes, Judge, I believe we spoke this morning with your clerk. The aggravated battery, we had to put the word permanent disability.
Your Honor, I think just we're nitpicking for the statute, and that was additional language that needed to be thought.
And we are working on that now, unless Ms. Corey wants to put it in there and then reprint it out. It's
You're
on
talking
the-
about when we talk about the forcible felonies?
No, under the definitions, Your Honor, the first one is assault, the next one is battery. And then
Right.
it talks about an aggravated battery is a battery which intentionally or knowingly causes great bodily harm, permanent disability.
Oh, mine says permanent disfigurement.
I think it's both.
It's both.
We have
Oh.
to add permanent disability.
Ah, okay.
So that was the issue that came up this morning. So we obviously have no objection to tracking the statute
Okay.
word for word. So,
Any objection to that, Ms. Corey?
I would only point out that if this were an aggravated battery case, choosing among those options, Judge, though you would not be reading all of them, you would go with whatever the state's approved, and that's the difficult part of this, is it's basically a fiction, because nothing happened in this for Dunn. He didn't get a scratch. So to add this, I guess you're saying it has to be in there just because it's part of the entire full definition of aggravated battery?
Well, the crazy thing about it is what you're doing is you're saying he believed that an aggravated battery could have been committed upon him. And so, ladies and gentlemen of the jury, an aggravated battery would include a battery, which is a misdemeanor,
Yes, sir.
that caused great bodily harm, which makes it a felony, permanent disfigurement, permanent disability, or used a deadly weapon.
All right. Just tell me where to put permanent disability.
I'd put it right after permanent disfigurement.
I think it was before.
Oh, was it?
All right, it's in there before, Judge, with the comma.
So it would be great bodily harm, permanent disability, permanent disfigurement, or uses a deadly weapon.
Yes, sir.
Okay.
And are all the commas there?
And the comma should be put out.
I've got the comma in there, of course. Judge-
Hey, don't ask me about commas. I know nothing about
Well, there's no
that.
definition of deadly weapon in here either. So where would this ever end, Your Honor? There's no definition of deadly weapon. Is the jury supposed to think that if Jordan had a stick, it
Well-
was a deadly weapon? Because it's not under the law unless it's used as a deadly weapon.
I don't know.
Well, I would like, if somebody can do the research, I believe I'm gonna highlight use as a deadly weapon, because I don't think this jury should be left with the impression that Jordan's fist was a deadly weapon, which it's not, unless used as one, that a stick is a deadly weapon. I think, I don't know if the word pipe came out, because I know I've seen it in discovery materials, I don't know if it came out on the stand, but I think you have to insert the definition of a deadly weapon so that we're entitled to argue Jordan Davis didn't have anything in his hands when he was being shot.
Well, you're going to be able to argue that.
Right, but the jury.
And clearly the argument is he didn't have anything in his hands, so we don't need to worry about a deadly weapon. He didn't have anything in his hands that could be considered a deadly weapon.
I don't worry about our arguments, Judge, I worry about what this jury goes back and gets to read without definition back there. Now, you've defined a firearm for is defined anywhere in these instructions. So all I am requesting is the chance to find out that when this is all read, as it is, it's
Okay.
stated entitled to have deadly weapon defined.
Okay,
And I've put a highlight on it for us to readdress.
okay. Sounds good. So we're still hacking around about justifiable use of deadly force. That's okay,
Yes, sir?
as long as we got the rest of it good to go.
Thank you.
All right. Well then, we'll work on that.
And then we're gonna have to also change, just for Ms. Corder, we also have to change, when we did the permanent, disability, it has to be in 3 separate spots, so I just wanna make sure it's in all 3 that Ms. Corder
Right.
gets that. Okay, I didn't want her to change it on the first one, and then there's 2 other places that all the definitions have to be read pursuant to the instructions.
You want to,
I'll change it, Judge.
pardon? You
I'll
get,
make those changes.
okay.
I just didn't wanna leave it, change it in one, Judge, and then leave it not changing the other 2.
How about looking at those verdict forms, make sure those are good? That change we made last night at 10:30,
I did-
quarter to 11, that worked?
Made a few more this morning. I've inserted 3 permanent disabilities with a comma. With a comma.
Hold that right there for 1 second. We find definition or something. Okay. Would not. I have no idea what I wrote there. Oh, that states that actually possess or discharge. Okay, that's.
Judge, for the verdict forms, I took out the mistake report caught. I deleted what I added in, that's deleted, and we lined them all up. I did take the A out because it's thrown all the formatting off. And so now it's just sub-findings. If you want the A back in there, I can do it, but it really, in line, almost any book, a lot cleaner, just lined up the way this is. But I'll refer to Mr. Charles' report on the verdict form.
All right, I had another question from the clerk. They wanted to make sure they had the right juror numbers.
I have a chart that has numbers on
I
it.
do too.
Yes, sir.
Juror number 1 was juror number 7.
Judge, my list is in my conference room. I thought we were way
Give me
past the
1
jury.
second, Judge, and I'll pull mine
I
up.
did too.
Sorry, Judge.
You with me, Miriam? You want these numbers? Juror number 1 was juror number 7.
Yes, sir.
Juror number 2 was juror number 10.
Yes, sir.
Juror number 3 was juror number 12.
Yes, sir.
Juror number 4 was juror number 18.
Yes, sir.
Juror number 5 was juror number 23.
Yes, sir.
Juror number 6 was juror number 36.
Yes, sir.
7 was 46.
Yes, sir.
8 was 55.
Yes, sir.
9 was 62.
Yes, sir.
10 was 64.
Yes, sir.
11 was 67.
Yes, sir.
12 was 70.
Yes, sir.
13 was 73.
Yes, sir.
14 was 82.
Yes, sir.
15 was 83.
Yes, sir.
And 16 was 87.
Yes, sir.
No, my chart's back in the conference room.
All right. So, I'll give you all that back. I've got some orders that I owed everybody. And I think I still may have 1 or 2 more coming. found one in my office as well. So here are the originals, and I have copies for the state, Mr. Strello. And let me talk to you for a second, since we're 5 minutes after about getting started at the sidebar. Yeah, I think what we'll do is take a break until 10:20, and we'll start at 10:20. So we'll be in recess until 10:20. Can you look back at something, or is there a way for me to look back to yesterday morning at 8 o'clock when we started to see what I said about people can come in or something like that? Is that gonna be on there? Oh, you could fall. How many pages yesterday? It's all Kathy asked. Oh, it had to be. Oh, I'm sure. Because that was 8 to 8.